My name is Mohan Shrestha, student number EKM3101. Today we are going to present a case study of ASHAC versus Sino Australia Oil and Gas Limited. The case is mostly related to the duties of board of directors, where most of the directors miss their duties. ASHAC started an investigation on March 2014 and investigate whether company has contravened various provisions of the Act during the initial public offering. Sino and its director were accused on breaching various provisions of the Act. Special focus was on the accuracy of statement published by the company, as there were some concern on the oil service contract entered by Sino Australia Oil and Gas Limited by one of its subsidiaries. There were many concerns raised by ASHAC's inquiry regarding the Huyang Oil Drilling Service Company Limited with various Chinese-based oil companies. Federal Court made order on 13th of March 2014 regarding the application of ASHAC pursuant to Section 1323 of the Act. This order restrains Sino and others from dissipating, transferring, and dealing all funds held in Sino's Australian bank account received from the initial public offering. This restraining order was continuously extended by the court on a number of occasions. Then on 4th May 2015, Board of Sino was resolved to appoint administrator to the company. Company also passed some resolutions as it was deemed that company is likely to become insolvent soon. These various resolutions included inter-administration of company investigated certain matters and events about the affair of the company between 4th May 2015 and 21st May 2015. They also had meeting with ASHAC and discussion of proposal for deed of company arrangement. Then again on 15th May 2015, Australian Security and Investment Commission ordered to pursuant to Section 447A of the Act and terminated the administration of Sino. In this case, most of the director duties have fiduciary duties versus statutory duties. In the fiduciary duties, act bona fide in the interest of organization, should act in a good faith, exercise care, skill, and diligence, exercise the powers of the purpose for which they are conferred, retain their discretionary powers, avoid conflict of interest. Statutory duties are care and diligence, good faith, use of position or information, disclose of interest, voting on matters in which a director has an interest, trading while insolvent. Some of the consequences of the breach of these duties are director can be liable in civil and criminal law. Penalties range from imprisonment to substantial fines, disqualification from the position, damage of professional reputation. Duty of care, ASHAC versus Sino Australia Oil and Gas Limited. Sino Australia Oil and Gas Limited is an integrated technical service company which provides enhanced oil recovery and underground work consultation services for oil and gas drilling enterprises in mainland China. The company operates through drilling and maintenance segment, which was founded in 2009.
Hi, my name is Benita Posnet Thapa. My student ID is FA3968. Here we are talking about ASIC versus Sino Australia Oil and Gas Limited. Here we're going to talk about duty of care. So when we introduce Sino Australia Oil and Gas Limited, it is an integrated technical services company which provides enhanced oil recovery, EOR, and underground work consultation services for oil and gas drilling enterprises in mainland China. The company operates through drilling and maintenance segments. It owns patented 2 EOR drilling technologies, including radial hydraulic jet drilling and status monitoring device for enhancing the recovery efficiency of oil or gas assets and lengthen its productive life. The company was founded in 2009 and is based in Subiaco, Australia. Here is the contraventions by Sino. A misleading or deceptive statement and omission from the disclosure document of material which is required to be disclosed under Chapter 6D, or a new circumstance that has arisen since the disclosure document was lost and would have been required to be disclosed under Chapter 6D. Here are some ASIC's allegations in which it was made false statements in the prospectus in relation to patents claimed to be held by the company, failing to make disclosure of material information concerning the profit downgrade for the 2013 year from the profit forecast in the prospectus, omissions from and misleading and deceptive statements in the prospectus in relation to a loan and certain service contracts said to be held by the Chinese subsidiary, making false statements in the prospectus and the provision of false information to its auditors in relation to certain financial information of the company and the Chinese subsidiary, and misleading and deceptive conduct in respect of the financial position of the company and the subsidiary. So, contraventions by the chairman are made in A6. So, failing to understand the prospectus documents he signed off on despite not speaking or reading English, and failing to obtain a Chinese translation, failing to acquaint himself with the disclosure requirements for ASX-listed companies, failing to disclose to the board that CNO's profit forecast disclosed in the replacement prospectus would not be achieved, and by seeking to quote CNO to transfer approximately $7.5 million to its Chinese-based subsidiary without providing the board with a proper explanation for the transfer, and without taking steps to ensure that the loan would be recoverable.
Hello, it's me, Vijay Rana. My student ID is EMV3656. As they already mentioned, my topic is about the federal court decision. CNO Australia Oil and Gas Limited was a liquidation, as the company had to pay pecuniary penalty of $800,000. Its former chairman was Mr. Tiapeng Sao, who is disqualified from managing corporation for a period of 20 years. And there is a message for all directors that how they can conduct all those things, like importance of due diligence process for the lodgement of disclosure documents. It is not simply enough for directors to review the final version of prospectus or to leave the responsibility of due diligence to others. Signing off on a prospectus when its contents are unknown so as a complement disregard for director duties of care and diligence. And in this way, director must ensure that they take the responsibility for their own action by informing themselves of their disclosure obligation and taking a critical active role in a due diligence. And there's an impact on the decision on the operation of companies in Australia. The points are like: impose the maximum pecuniary penalty payment as $1 million for entities from emerging markets seeking and obtaining listing on the ASX, particularly from the Asia Pacific region. And in this way, the court accepted that people contemplating entry to the Australian market must familiarize themselves with and understand the rules of market and adhere to those rules. Thank you.
Thank you very much for this is the end of our presentation. Thank you.